All right, everyone, why don't we go ahead and get started with panel 3. Make sure we have all of our guests with us. All right, so it's my pleasure to moderate our third and final panel today because I handpicked these people, and these are some of my very favorite people and colleagues in the field. And one of the joys of my job is being able to bring together some very smart people whose work I admire and have them speak about things that I'm interested in. So with that, I will get out of the way and let them go. I will begin with our colleague at Michigan, Nicholson Price, and then I'll ask Glenn Cohen from Harvard Law School to speak, followed by one of our wonderful collaborators at the University of Ottawa, Colleen. And then we'll conclude with Zubin Khambatta from Perkins Coie, our partner today, who's done an excellent job helping us bring people together and host. So I'm going to have each of them speak for 10 minutes. And when 10 minutes is up, I'll just cut their mic and we'll go to the next person. All right. So Nicholson, it's all yours.
All right. I can't see myself, so can you see and hear me, Nathan? Please wave if you can. All right, great, terrific. Well, I'll just assume that I'm in frame and oh, there I am, hooray, fabulous. So thanks so much for having me here. It's really a pleasure to be chatting with you today, and I'm sorry that I'm not there at SMU, which I understand is sunny and paradise-like today, as opposed to Michigan, where it's cold and icy and snowy. So I'm really, just start off, I'm going to say like things about how there are problems, but just as a baseline, I'm really excited about this area. I think there's so much exciting work going on in the context of AI in medicine. I just think it has tremendous potential to really democratize expertise and get good medicine into the hands of lots and lots of people. And so the question is, right, how do we do this right? How do we make sure it actually works? And so I want to focus on the need for governance and why, despite what I think is really excellent work by the FDA, by Bakul Patel and his team and all of the folks there, they're only getting at a part of the problem, and why localized governance is probably necessary, which is unfortunate because it's likely to be really hard. But how we should think about this question of distributed or localized governance and how policymakers can help. So for starters, I don't think I need to do a lot of convincing to demonstrate that, right, we need governance and oversight of medical AI. It's a new technology. There's a lot going on. There are a lot of things that can go wrong, especially when things are changing quickly, when they're often opaque, when they're not always explained. We've seen quality control issues just in the last year in terms of the evaluations of the many COVID-19 tools that popped up and turns out were really exciting and often didn't work at all. Epic's sepsis predictor has had lots of problems shown with it, indeed some of them by my colleagues here at the University of Michigan and Karandeep Singh's group, right? Deployed across the country, frequently not actually great at working. Deterioration algorithms, where we were predicting when patients would run into problems, and it turns out they all basically broke when COVID entered the picture. Not all of them broke, but lots and lots of problems. Problems with quality, problems with bias. There's a well-known study about United Healthcare's algorithm for predicting which patients needed more follow-up care. As Ziad Obermeyer pointed out, this was trained on what kinds of patients had received care in the past, which has huge racial bias implications. So we need some sort of oversight. And of course, the place we first look, understandably, is FDA, right? FDA is the regulator of medical technology, at least in the US. And as we just heard, they're thinking about this in what I think, frankly, are really great ways. They're thinking about software in medical devices, software as a medical device. There are people that make arguments that say 510K equivalence doesn't really make sense for artificial intelligence, arguing about pre-cert, whether the bar is high enough. Frankly, that's really just not what I'm worried about. Sure, there are things one can quibble about in that space, but overall, FDA is doing a really thoughtful job trying to deal with these questions, and you can question its approach, but it's working on it. The problems that I see are twofold. The first is what FDA doesn't see, and the second is what FDA as a centralized regulator really has a hard time doing. So on the what FDA doesn't see, I've kind of previewed this by my question in the last panel, which is there is, not a question, it's a statement, like there's so much AI out there already being used that FDA doesn't see at all, right? We talked to people developing products in the first parts of this panel, and that's awesome. And there are hundreds of algorithms and products that have gone through FDA clearance product pathways, and that's awesome. But there are tons of AI systems and AI products that, well, I'm not gonna use the word product, I'll set that aside. AI systems and algorithmic systems that are in use right now in the context of healthcare that FDA just doesn't see at all. On the first side, there are these in-house things that I'm particularly interested in. I've done work with this on this with Rachel Sachs and Rebecca Eisenberg, thinking about AI being developed in-house by both health insurers and by hospitals and health systems. University of Michigan has a bunch of algorithms running. Turns out lots of fancy academic medical centers have algorithms running. Duke has them, NYU has them. I suspect SMU has them, although I don't know that. I'm sure I know that Harvard has them running, right? These are things that are in place, affecting patient care, making predictions, making recommendations right now on the private side and on the public side. In addition, to the best of my knowledge, no algorithmic product developed by an electronic health record vendor like Epic has gone through the FDA clearance process. And yet they're distributed nationwide to electronic health records, tons and tons of places. So lots of stuff FDA just isn't seeing. It's also the case that even the stuff that FDA does see, it's a centralized regulator, which is great when the question is, here's a drug, I expect it to work basically the same on everybody. It doesn't, but we'll ignore that. It's much harder when we're talking about a product like like AI, which is very frequently going to behave quite differently depending on the medical context. Different patients, different resources, different workflows, different patterns of care, different information technology and electronic health record environments all mean that AI products are very frequently going to behave quite differently and need their own validation, their own tuning, their own careful implementation and integration on a context by context basis. They're going to have to be integrated at the level of the health system, not at a nationwide level. And what FDA does is nationwide evaluation. Now, this isn't always true, right? Some of the products that go through FDA do a great job of saying, look, we're not going to be contextually variable. Things like IDXDR, where they said, look, we're going to establish our own camera system that you have to use because we don't want local practice patterns or individual variation screwing up the images that we're going to use to diagnose diabetic retinopathy. And for things that are purely evaluations of a physiological signal we shouldn't expect to change across populations, great. But there's tons of good stuff that AI can do outside that context, like deterioration or infection prediction, sepsis prediction, patient flow, so many tests that can make such a big difference, but are not amenable to this sort of centralized evaluation. So what do we do instead? Well, what institutions have been doing that have been developing their own products or importing them in-house is localized governance, where they try to figure out on their own, does this work and how do we show it? It turns out it's really hard, right? So for Duke, they take everything through a stage gate process. They measure the outcome, they identify the outcome measures they want to use, check for performance and improvement targets, do retrospective data validation, then validate it on current data, run it in the background, checking their metrics with beta testers with delayed things so it's not actually affecting patient care, then run a prospective study, consider it for workplace integration, and eventually, if all that works, bring in information technology, individuals who do just evaluation, clinical stakeholders across a ton of departments. University of Michigan was the same thing, but through a clinical structure, clinical informatics committee, where we've got representatives from a bunch of different departments, physicians, pathology, nursing, research, information technology, learning and health systems, guests, ad hoc members. NYU does this whole process, but keeps everything in-house. They've got their own whole in-house development and evaluation unit that's part of their IT system for NYU Langone. This takes a ton of work and a lot of resources. And often that's just going to be outside the capacity of what many places can do, especially the places with lower resources where we should be most worried that products developed in fancy places won't work the same way. And B, they don't have the resources to do this kind of intensive evaluation. So what do? Part of my answer is, I don't know. I don't have a great solution, and I would love thoughts. I have a couple of thoughts. I don't think they're enough. So what are my thoughts? Part of this, outsourcing evaluation. FDA does a little bit of this. OCHIN, there are some nonprofit and for-profit vendors that try to do evaluation with a little bit more specificity as to what type of organization you are, but they still fall for some of the contextualization issues I just mentioned. They're not a solution. The other thing I can think of is trying to reduce the cost of doing this in-house evaluation by building capacity, and that's hard. Some ways are particularly tough and resource context specific, like developing and supporting the use of IT systems, trying to support human resources, making training easier. But some of these things are a little bit more shareable. Thinking about infrastructure, knowledge infrastructure, about best practices for how to evaluate products and how to integrate them into workflows and how to make sure they actually work. That's something where those ideas can be developed centrally and then distributed, not because they'll evaluate tasks, because they'll evaluate products on their own, but because they'll make that evaluation easier. Two other types of infrastructure. One of them is data, building wide representative data sets so that we know what sorts of variations are important to look like or to look for, and what sort of quirks arise in different contexts. And last, frankly, legal infrastructure. Things like making data sharing easy, facilitating interoperability and transparency, because all of this requires the ability to look into a system and see what's going on and see how well the AI system is going to work within that particular context. This isn't easy, it's hard, but I can't see a way around it while making sure that this actually works and that it works for places that don't already have a huge number of resources to make it work. So this is what I see as a big challenge. Again, incredibly exciting area, but to really reap the full potential of AI across various contexts, we're going to have to make sure they can actually govern and evaluate it and integrate it at a local level. Thanks so much.
That was impressive, Nicholson. Just on time, 10 minutes exactly. 10 minutes exactly. All right, let's go to our next panelist and one of my co-authors, Glenn Cohen.
Great, I think we're on. You're gonna run my slides. All right. I'll wait till they're up before I start talking. Nathan, this doesn't count against my time, right? There we go. Now that I know I have to beat Nicholson's precision. Okay. Thanks everybody very much for having me. Ron, if you don't mind moving to the next slide. Just very quickly, here are my disclosures. Next slide, please. So I'm going to talk about a few different issues, kind of a potpourri. 3 issues that are emerging in medical AI and ML. It's really lovely to be here. Nathan's such a great host all the time, and some of my favorite people here. The first is really informed consent. So one of the most interesting features about the likely future of medical AI is that we won't always know it's there. We won't be knowing we're dealing with an AI. At this point, if I had more time, I'd probably play this little clip from Google Duplex, where someone is making a reservation at a Chinese restaurant, and I ask people to guess who is the AI in the situation. And people often get it wrong, even when they're primed that there's going to be an AI. And this little guy over here, this cute little guy, is Paro, the robotic seal, who's a therapeutic robot, a form of social robotics given to patients who are elderly, many of whom don't know he's also a little spy, reporting data and information back to neurologists, among others. Those are dramatic examples, but the more quotidian example is, just imagine you're going for a surgery. Let's say it's a prostatectomy, and your physician is advising you amongst the 2 options and makes a recommendation. They go over all the benefits, they go over all the risks, and they say, for this reason, I think you should go for prostatectomy rather than watchful waiting. Do they have an obligation to tell you that an artificial intelligence was involved in making the decision? That it looked at things like your tumor size, your age, other personal characteristics in your EHR data, and maybe married to non-EHR data. They failed to do so. Would they have violated an ethical duty to you? Would they have violated a legal duty to you? This is not just hypothetical. In 2019, Lancet HIV published a good study that used electronic health record data and machine learning to predict whether a particular man who is at high risk of contracting HIV should be recommended to use PrEP, pre-exposure prophylaxis, or not. And the question in that example for me is, if you have a tool that's advising the physician whether to have this conversation, does that have to be disclosed to the patient? So I wrote a long law review paper. They're always long if they're law review papers on this for the Georgetown Law Journal a couple of years ago. You can read it if you're interested. But I find it useful. Here's the capsule version. I find it useful both normatively and legally to think about analogies here. Is this like failing to disclose to someone that a substitute surgeon is going to scrub in? Is this like failing to disclose that there's going to be a resident who's never done a procedure before involved? Or is this like failing to tell a patient that when you decided to do X rather than Y, you thought about, among other things, a medical school lecture you had 7 years ago, the last 6 patients you saw, the last 3 journal articles you read on the subject a couple of years ago, ... Now, the latter is something that we don't think people have an obligation to disclose as physicians. And if a physician did disclose all that, we kind of think the person was a little bit weird, to be honest. Is the involvement of artificial intelligence and machine learning in healthcare more like that latter example, or is it more like there's somebody else involved, as in the substitute surgeon? And how should we think about it? Does it matter whether the AI ML is explainable or interpretable or none of the above? Does it matter if the physician has the ability to overrule the AI ML, or is that irrelevant? Does it matter whether it's gone through FDA review, one of the small numbers Nicholson says it has, as opposed to being a home-brewed system? Okay, lots of questions. Next slide, please. All right, so many people, I'll wait till the slide changes. Many people are quite enthusiastic or think the explanations are very important in medical AI. The black box nature of predictive algorithms are a core source, many people say, of user skepticism, lack of trust, slow uptake, et cetera, et cetera. As a result, there's been a big push to say, and we saw this in one of the early panels today, explainability is a sine qua non. We must have explanations for black box algorithmic decision making. This is a consensus. We're also seeing it, I would say, in legal materials, in civil society groups, in governments, et cetera, by academics. In this paper in Science, we're kind of contrarians. We try to show that the consensus, at least applied to healthcare, both overstates the benefits and undercounts the drawbacks requiring black box algorithms to be explainable. Now, what do we mean by these terms? When we talk about a black box algorithm, we mean the estimated function relating inputs to outputs is not understandable at an ordinary human level, owing to, for example, the function relying on a large number of parameters, complex combinations of parameters, or nonlinear transformation of parameters. There are 2 categories of things that are used here as solutions that are often confused. One is to require interpretable algorithms. An interpretable algorithm roughly does the following. Instead of using a black box function, it uses a transparent white box function that is an easy to digest form. For example, a linear model whose parameters correspond to additive weights relating inputs and outputs, or a classification tree that creates an intuitive rule-based map for the decision space. We could, for example, use interpretable algorithms. We could say the rule is you must use interpretable algorithms. That would be a good rule to debate. It would rule out much of medical machine learning we're doing right now, in particular deep learning, but it would have some advantages. But people want to have their cake and eat it too. And so the solution that's proposed is an explainable algorithm. We don't require it to be interpretable, just explainable. How do you turn a black box into an explainable algorithm? Given a black box model that is used to make predictions or diagnoses, a second explanatory algorithm finds an interpretable function that gets the outputs of the black box. The second algorithm is trained by fitting the predictions of the black box and not the original data. And it's typically used to develop a post hoc explanation for the black box output and not to make actual predictions, because it's typically not as accurate as the black box. The explanation might, for instance, be given in terms of which attributes of the input data in the black box matter most to a specific prediction, or it may offer an easy to understand linear model that gives similar outputs as the black box. Other models like counterfactual explanations or heat maps are also possible. In simple terms, explainable AI ML finds a white box that partially mimics the behavior of the black box and then uses that as an explanation of the black box prediction. Importantly, this approximation can't be perfect, because if the white box is a perfect approximation, there would be no difference between the two. It's also not focusing on accuracy, but on fitting the black box, often only locally. And importantly, these explanations are post hoc. Why is all that a problem? Because the rationales of black box predictions are not necessarily the actual reasons behind those predictions. They're a kind of explainable fool's gold, because they're unlikely to actually contribute to our understanding of the inner workings of the black box. We call this ersatz understanding. And the best analogy I can give you is actually a bouncer at a club. If I show up at a club with two other men and a woman, the bouncer might give me an explanation for why I'm not let in. We don't allow people in with sneakers. And indeed, that may fit the data pretty well, since most folks come into the door who returns away are wearing sneakers. But the real reason I'm not let in is because I am a dude, and they want a certain gender balance in the club. And so it happens that no or very few women actually wear sneakers to a club. The white box is the bouncer's explanation given, but the real rationale remains hidden. And if the comfort of explainability fools me into thinking I have it right, that can be problematic. And this is particularly problematic because we are bad reasoners as human beings. We are drawn to narrative fallacies. And the way we understand the world is through explanations that are intuitive, but the underlying relationship might be quite unintuitive. But it gets worse. For an explainable algorithm to be trusted, it needs to exhibit some robustness. By this, we mean the explainable algorithm should ordinarily generate similar explanations for similar inputs. However, for a very small change in input, an approximating and explainable AI might produce very different and possibly competing explanations, with such differences not necessarily being justifiable or even understood well by experts. And we're losing a lot in these models because with massively high dimensionality, such as image recognition or genetic sequence analysis, limiting oneself to algorithms that can be explained sufficiently well could unduly limit model complexity and undermine accuracy. And for what? So our point is, stop focusing on explanations, focus on data that shows safety and effectiveness. That's what we care about, not coming up with a post hoc explanation. Okay, next slide, please. Last thing I'm going to say is just to say, when FDA is involved, when you have pre-market review, there's this question, and I pressed Mr. Botello on this, of when you should require what kind of evidence. Should we be requiring randomized trials before you go out into the world and use these things? One problem we point out in the system view paper, and this jives with what Nicholson was saying, is that unlike drugs and devices, who are things that work in a relatively invariant way, depending on the context, when it comes to AI ML, it's very sensitive to a host of lots of contextual factors, interactions between different parts of the care team, the payment structure, data providers, software component providers, trainers. That's even if you had great data that was locally sourced. What do you do when this is the problem? We suggest you need a much more systems view of approval. But when you do so, you run into a different problem, which has to do with updates. Because when these things are approved, pre-market review, you have this problem to say, what happens when we updates in real time? We don't want to say they are forever law. We don't want to say stop learning, stop gathering real data in the real world. But as Mr. Patel said, while you can pre-specify how much of a change is enough to trigger a re-review, turns out in practice that's extremely difficult to do, and it may not be the best way of thinking about what conditions are that should trigger a re-review when there's an update. Lots more to say in the Q&A, but I'm going to stop there. 30 seconds over. Sorry, Nathan.
I had you right at 10 minutes, so you didn't have to admit to that 30-second overlap. All right, so another one of my favorite people and a frequent collaborator is our colleague in Ottawa, Colleen Flood.
Cool. Hi, everybody. So my pleasure to be here virtually. I wish too that I was with you in person. It's pretty cold and snowy. Thank you so much, Nathan, for inviting me to participate, and to the whole team at SMU for organizing this. It's really been a fascinating discussion throughout the day. You might tell that my accent is originally from New Zealand, but as Nathan mentioned, I'm in Ottawa, Canada right now, and I'm going to talk to you a bit about Canada's approach to governance of health-related AI, and I think it picks up some of the questions and issues that Nicholson has discussed, and Glenn as well. Canada is one of the most disaggregated federations in the world, and governance of health and healthcare is quite difficult as a result, because there are overlapping jurisdictional possibilities for both federal and the 10 provincial and 3 territorial governments that make up our country. And often this leads to a lack of accountability and blame shifting between governments as to who in fact is responsible for problems in access, efficiency, and quality. And with that backdrop as our primary focus, our recent work with colleagues like Michael De Silva, who's in the audience, and innovators like Anna Golding from Vector, and Devon Singh from Sick Kids, Teresa Skaza and others, we have really focused on the federal government's regulation of health-related AI through its regulation of medical devices under Canada's equivalent of the Food and Drug Act. And for us, this is because the federal government has clearly taken on this area of responsibility, the safety of medical devices, which and the definition has been expanded, as we heard before, partly because of discussions across different regulators around the world, to include AI software alone. And so there is significant potential from our perspective if the federal government can get this right at the national level, to create a set of needed incentives to ensure production of high quality AI for all Canadians and all Canadian healthcare markets. Now, other domains may drive or speak to safety in some regard, of course, for example, private tort or contract law, or more general calls, as we've heard a lot of today, to industry to behave ethically, or calls for better education of the medical workforce are of course important, and the various validation mechanisms, local governance, as Nicholson described. But this impact is more diffused and importantly may only have impact after harm has occurred. It does seem to me and to my colleagues that working to set better standards with clarity nationally for entry into markets, particularly around issues of safety, will in turn kind of provide a dynamic back and forth with private law, with ethical codes, with industry practice, and so on, for the betterment of all. Now, we were all aware, I think, of the vast potential of health-related AI to improve access, timeliness, and quality. And for example, our existing human-only decision-making in healthcare, well, that's an understatement, but you know what I mean, leads to unacceptable errors, medical error, causing suffering for thousands of Canadians and Americans every year. On the other hand, Glenn, Nathan, and many others here have written eloquently on the potential risks of health-related AI for safety, for privacy, discrimination, informed consent, and the regulatory challenges that are posed because, for example, the processes by which ML learns and updates itself and as it evolves is opaque. And the types of AI that are out there are as heterogeneous as the healthcare applications. And I guess this milieu as well means that it sort of generates this sense, and we often hear this, that regulation is antithetical to innovation. But for me and for many, I think the project of realizing the fruits of innovation for people this project itself will be deeply undermined if the real risks of AI are not attended to through adroit regulation. And, you know, sometimes this has been described as the inconvenient truth, and that a few bad apples or a few bad products could significantly undermine the trust of both healthcare providers, of patients, and the public more broadly. But apart from the fact that smart regulation and good regulation can help support wonderful innovation, it is, in my view, really the essential duty of government to protect patients from avoidable harm, from the charlatans, the snake oil manufacturers, and the carbolic smokeball folks of our age. So when we look at the present Canadian regulatory regime, our conclusion is that there are too many holes within it. And some of these holes seem to have been almost deliberately, or that's not the right word, they may have been permitted to widen, perhaps in the mistaken view that this will support AI innovation. For example, many health-related AI tools that we have in Canada presently avoid regulatory oversight because the sponsors themselves decide on which risk category they fall within. And there's really little transparency about the extent to which Health Canada, our regulator, actually reviews that decision-making. Similar to the point that both Nicholson and Glenn were making, we also have the issue where innovation developed within hospitals, because it's not commercial, it's just used within the hospital itself, also falls outside the purview of regulation. Further, less or no regulatory oversight is generally justified on the grounds that there is, in effect, a human in the loop. And to me, this is very puzzling. Recall that one of the benefits that AI can bring to healthcare relate to the fact of imperfect human decision-making that in Canada at least results in at least 70,000 highly preventable medical errors each year in hospitals across Canada. And given that fact, it does seem to me unrealistic to imagine that human physicians, nurses, and pharmacists at this point still largely untrained even in the basics of how AI functions or can be relied on, will be able to identify and ameliorate AI risks in application. And I would just note that we do have humans in the loop in prescribing drugs and so on, but no one suggests that that alone is sufficient protection. So another problem, and this picks up on the issue that Glenn mentioned in Canada, is the problem that Health Canada, our regulator, is presently not transparent about what standards of evidence are in fact required for approval for different risk categories. The gold medal standard of our randomized controlled trial is generally not required, but I think we need to have more transparency and a clarity about what is required for clinical proof of effectiveness, depending on the general risk category. Another hole in the Canada's regulatory requirements is that there really is no specific oversight or clear requirements about the issue of algorithmic bias as part of safety review. In my view, algorithmic bias clearly is a safety issue if, as a result of excluding various populations from the training data, the ultimate tool may misdiagnose or result in undertreatment or overtreatment of a particular population. This is a safety issue. In our view, this is an area that our regulator, Health Canada, should step up to the mark on and ask that sponsors demonstrate that they've taken all reasonable measures to access data that is representative of the population on which it will be used, and greater government efforts are needed to ensure access to better data for all AI and ML innovators. A final and important gap in the oversight is that up until very recently, adaptive machine learning was not able to be licensed by Health Canada due to restrictions, as Glenn just mentioned, it's evolving over time. Does it have to come back for relicensing? That's not really feasible with machine learning, as it's adapting and changing in real time. Amendments have now been made to our legislation to permit a new pathway for approval of adaptive ML and other novel technologies, indeed. And all of this is to be welcomed. But Health Canada, again, as our regulator, has not made it clear what will be required in terms of the standard of evidence for approval. They talk of, and I think you have the same language of this new adaptive pathway and experimenting in the regulatory sandbox. And all of this will put more emphasis on post-market review, likely with audits of machine learning products from time to time and reporting requirements on the part of innovators and the users of AI if there is a significant change in performance. But again, though, and this may be a function of its newness, there's very little transparency about what those standards will be, how the reporting will be enforced, what kind of audits will actually come to pass. And I think there's a flavor in all of this in the development of the post-market review pathway, that the quid pro quo, I guess, for the industry, I guess, permitting or being subjected to this is that there'll be a lighter pre-certification system, perhaps mirroring the US's pilot pre-certification system of the sponsor or the innovator as opposed to the product. I think my view here is that there really are too many holes in the regulatory oversight, and that we need to ensure that best practices are followed in the design of health-related AI for both products and for sponsors. And for example, regarding the use of representative data sets, we should really prevent harm to patients rather than to react to it after the fact. And so both pre and post-market oversight and review are essential. And to me, it would be terribly short-sighted to concede that pre-market clearance should be given up or significantly watered down as some form of interest group exchange for compliance with post-market review requirements. So in conclusion, I think as with everybody, we know that there is a really wicked problem here in terms of a significant regulatory challenge. And I think legal scholars and thinkers like the folks on this panel and all throughout the day need to help regulators around the world to meet this challenge, to ensure high quality health-related AI is able to quickly enter markets to help patients. But with as much determination, I think we need to make sure we have processes in place to weed out bad products and bad actors. The worst of all possible worlds, in my view, would be what I call rhetorical regulation, where the product appears to be regulated and patients, providers, and hospitals, etc., rely on that appearance of regulation for it only to be subsequently revealed as a hollow promise. And I think, the last couple of years in Ottawa, the last couple of weeks have taught us anything, is that faith and trust in governments has eroded significantly. And we really must collectively do a lot better to justifiably keep the public trust. So I'm sorry, I was not at all watching the time, Nathan, so I apologize if I've gone over.
Thank you, Colleen. You are well within permissible limits. So let's go to our final speaker, who is on the front lines here, practicing, representing a lot of companies in this area, practicing down in Austin with Perkins, Zubin.
Good afternoon, everybody. It's great to be with you. Can you hear me okay? Okay, great. Yes. Thank you. Yeah, there we go. My video just popped up. So I haven't prepared extensive remarks here. It's been fascinating to listen to this panel and others today. And really hear their insights into this very dynamic area. I can only really speak from a practitioner's perspective. And to that end, I've got, I guess you could say, three comments from that perspective that I'll try to convey here, and understanding that I may be covering some territory that others have already covered in certainly in a more erudite fashion than I'm able to. From a practitioner's perspective, one of the things that we see are what are the dynamics out in the marketplace that are sort of driving AI and that raise legal issues and regulatory issues. And one of those, I guess you could put it under the general heading of various kinds of market forces where AI would be looked upon as a kind of a substitute for professional medical judgment and professional services. Not just a complement for it, but to some extent a substitute for it, where you would have quote unquote mid-levels relying or using AI, and that combination, for example, substituting for physician services or the exercise of a professional judgment of a physician. And of course, those market forces are driving towards efficiencies, driving towards being able to provide services in the marketplace in a cheaper way, driving towards accessing markets in ways or segments of markets that the existing healthcare system doesn't do very well, and looking, quite frankly, looking for reimbursement opportunities and profit opportunities. And that is something that we see, and I think drives how we think about regulation from a practitioner's perspective. What are the kinds of things? What kinds of issues does that raise for a regulator, and how should we be advising clients accordingly? The second dynamic here, and I think this is one that's been talked about pretty extensively, is the ability for AI to increase the efficacy, the accuracy of diagnosis and treatment. And that's certainly, there's a tremendous promise with AI. Everybody recognizes that. And there's a question, of course, for regulators of trying to incentivize that, certainly not trying to disincentivize or block that promise of AI at the same time, and people have talked about this, ensuring adequate attention is paid to safety, and adequate attention is paid to misleading people and issues of informed consent and that sort of thing. And then a third dynamic I think we're seeing is kind of intersects with health equity. So there's certainly a lot of discussion in literature about AI, about how AI can build in biases, but there's also a promise for AI to actually correct for biases, and to do better than existing modalities in the delivery of healthcare when it comes to overcoming or muting the effects of various kinds of biases. And in that respect, being raising the possibility that you could promote health equity in that way. And so I think that's another. So these dynamics, I guess my first comment is that these dynamics really impact how we as practitioners look at AI and how we might counsel clients as to what they need to be thinking about. Where do they fall within these different buckets? Or there's certainly other buckets, I'm sure there's ways in which these issues overlap and things like that. The second comment I would make is, we're of course concerned with what are the existing regulatory frameworks. And there's been, of course, a lot of discussion today about the FDA and their role in regulating AI. And there's also the prospect for, looking at AI through the lens of a learned profession and the regulations of a learned profession, and the regulations pertaining to licensed professionals, physicians, et cetera, and their use of AI. And how do those regulatory frameworks, which aren't necessarily particularly attuned to AI, how do those apply? And what should we be thinking about there? And ultimately, is AI better regulated as a medical device, or is it better regulated in the way that learned professions are regulated in terms of regulating professional judgment? Or do we need a third category or a different category? I think related to that is, who, from a legal perspective, who's responsible for the AI? Who's responsible for the outputs and the impact that the AI has? Is it the manufacturer? Is it the professionals or the healthcare organizations that deploy AI? Is it the AI itself? I don't know. Could you sue an AI at some point in the future? Would they have personhood to be sued? That's obviously a kind of almost a law school exam question. But the idea is, who's responsible? I think that's certainly something we're seeing clients be concerned about. Where does the responsibility lie? And I think related to that is, where is the primacy with respect to AI? Is this really a tool for physicians and other professionals, and the AI is subordinate to that, or is it more independent, and does it need to be regulated in a different way? And then the last comment I would make is, what does AI, what is the impact in thinking about the standard of care when it comes to the practice of medicine and the delivery of healthcare services? How is it going to impact the standard of care? Are we going to start to see an evolving set of legal standards that say, what are they going to say about AI? Are they going to start to say that AI has to be utilized because it's better as a matter of standard of care, and that the failure to incorporate AI may be an issue? And of course, there's all kinds of distributive issues of who can use AI. It's obviously an expensive technology. A lot of the work I do is involving indigent care and providing care to the indigent, and how are those kinds of populations going to get access to AI, and how does that impact these issues? So those are kind of three general comments I had, and I'll stop there and turn it back to Nathan. And it's great to be with you, and I really appreciate listening to people who've been studying this issue so extensively. So thank you.
Wonderful. Thank you, Zubin. So we have some time for questions. Let me solicit questions. If you're in the audience here in person or on Zoom, go ahead and raise your hand or put a question in the Q&A. I want to begin by throwing a grenade to our panelists. We've spent a lot of time rightly focusing on whether and how to adopt AI in the first place, how to ensure that it actually works and is useful and is meaningful. What happens if something goes wrong? What happens if it does have an adverse effect on clinical care, or it does generate mistakes in a specific instance, or certain patients are left out? Where do you think liability resides? And the normative part, where should it reside? Who should be liable?
So I'm smiling because Nicholson and I just turned in a book chapter on exactly this topic at noon today, which summarizes some of our general thoughts. Maybe I'll just start, which is to say, typical lawyer answer, it's complicated. And it's complicated in part because actually, I think you can get into a lot of trouble if you don't disaggregate the different levels of players involved. And my general rule of thumb is, very, I guess, Posnerian in this respect. You should give the most liability to the person that has the most say in making the kinds of decisions that are relevant. And most people, I think, default to thinking physicians, well, it's just a form of malpractice. But actually, when I look at the ecosystem of AI adoption and AI use, actually, I think physicians have much less control here than do other entities, such that I think institutional liability and products liability probably more important than physician liability. But I think that actually, but if you look at the case law on the flip side, I actually don't think the case law, we don't have very much case law, but the application of general tort principles in this space actually reflects that kind of ordering. But I'll be curious to see what the other two think.
I unsurprisingly don't disagree with Glenn on this basic point. I'll take a brief step back to say that I think that in thinking about this, there's the legal question, where does liability lie? There's also the backdrop question, which is like, what's our baseline here? I think we spend a lot of time thinking about when AI is likely to get things wrong, which is certainly true. I think we spend a lot less time thinking about how screwed up the current system is, and fall prey fairly easily to the nirvana fallacy that what we have right now is a good system that provides high quality care to a lot of people. If, like me, you think that that is a deep, deep mischaracterization of the status quo, I think you got a little bit of a different view about exactly how concerned we should be about AI liability. Not that I think we shouldn't have liability, of course we should, but a kind of our baseline conception about what are our biggest worries. I worry more about AI not getting to get more care to lots more people, maybe even more than I do about AI making mistakes here and there.
Thanks. That's a great question, Nathan. I think the lack of clarity around liability can impact the willingness of healthcare providers and institutions to take up liability, particularly if their med-mal insurers are leery or uncertain. So the more that we can provide clarity in this regard, the better it will be. And, that's why in my presentation, I think I was trying to speak to the need for articulation of clear standards, product standards, and in Nathan's parlance for health-related AI. So, if, as Nicholson has said, the problem is that, we need to validate the AI in a context-specific way and within different hospitals and institutions, then it would seem to me that the rule should be at the sort of central level is that actually happens, right? That kind of validation actually occurs. And not that we just hope that it happens somewhere in the ecosystem. So I think, the clearer, without rules that don't change over time and space are terrible, but rules that can be filled with content and sort of self-modernizing over time, that's what we need to aim for, both in this and quite a few other spaces.
Can I pull up, Nathan, before you ask another question, one thread of what Colleen said, which is this question about malpractice insurers. So I think that an area where I'd love to see some empirical work, but it's very hard to do, is to understand what the terms of malpractice insurance is as to medical AI as used by physicians. Because as we know, in the United States, physicians are largely kind of insulated from actually paying due to health insurance or malpractice insurance. It's not very experience rated, ... So what the exclusions of the policies look like. But the other thing is to say, and many people in the audience may already know this, we've seen some interesting innovations. So with IDXDR, for example, indemnification agreements with purchasers and end users against that. It would be interesting to map whether that's a very unusual one-off because they were like first to market and very autonomous, or whether that's kind of something similar. And the last thing I'll say, and again, I've never litigated a malpractice case, so I may be totally off here. As hard as it is, the burden of discovery, improving violations of the standard of care and the like there is in an ordinary malpractice case, my own view is proving causation and breach of standard of care is going to be even more difficult, when the claim is the algorithm was incorrect or the reliance on the algorithm was problematic, such that I think that, you know, if you're thinking these cases are what's going to keep the makers honest, it strikes me as an unlikely fact of the world in terms of the litigation costs and likely outputs.
Nathan, if I could just jump in too on sorry to sandbag that, but I think, you know, this just to go back to the comment that I made about having providers in the loop, and you know, that is seen here at least to be a sort of security against error. And you know, I really think that that's problematic, given that it's the fact of human decision making. I totally agree with Nicholson. You know, this over romanticization of humans as physicians, nurses, and pharmacists is incorrect. But the providers in the loop, you know, as a source of security, and then I think, you know, what I see of my physician colleagues, some of them at least, when we get into this discussion, they're actually sort of mollified by this, right? That the jobs will still stay there, they'll still be in control, but with that goes this potential difficult questions of liability, and the fact that they may not actually really know what is happening with the thing that they're relying on, that they may assume is being properly regulated by somebody, but in fact hasn't been because of their role in provision. So I think there's some pretty knotty, woolly knots, you know, that's a very technical legal term, to unwind here.
All right. So we have a question from our editor-in-chief. In the context of artificial intelligence, machine learning, what privacy rights do you think digital twins should have? And what are the dangers of their misuse? This is especially relevant if the AI machine learning systems expand data.
Maybe I'll start. So this is my way of also saying, so Professor Cortez and I are writing a paper on in silico clinical trials right now. And as is usual, he sent me at the beginning of the week, a beautifully concise 1 or 2 pages. And I'm starting to cut down my 6 or 7 pages on exactly this topic. So I've been thinking about it. So here's my short version of it. There are digital twins and there are digital chimeras. Chimeras are stitched together amongst many different patients to make up for patients that are not actually represented. They're phantom patients. With chimeras, I think the privacy issues are actually relatively minimal because it's hard to unmake the omelet back to a person. With twins, I think the answer is there are some significant re-identification risks, especially if we build libraries of digital twins that are reused in multiple in silico clinical trials. But the existing health privacy laws, both GINA on the one hand, and then HIPAA even more so, it's actually a little hard to see where you get a HIPAA violation from the construction if you strip the 18 identifiers. There is some saving language relating to readily re-identifiable and the like, but not too many cases on that subject. I'll just say that I think an adjacent issue that's also interesting is when individuals should be consented to the construction of digital twins of them for clinical trials. So if my digital twin is going to undergo a whole bunch of in silico clinical trials, under what circumstances do I need to be consented for the construction of that digital twin or their use? And the answer is, again, it's complicated, but for that, I really do need the 5 or 6 pages.
You know, I think, I'm not sure if it's the same in the US, but in Canada, if the data is de-identified, then, you know, you're permitted to use it. And of course, the problem is with both with digital twin, but even more, you know, more generally, that, you know, sharp AI tools themselves can re-identify pretty quickly. And so, you know, it does seem that globally this has been recognized, not just in healthcare, but more broadly, that we have a problem with our extant privacy laws and they need to be rebooted. This is not my strong area of expertise. Every time I try to read our various privacy laws intersecting federal and provincial, I actually want to pull my eyes out of my head. But yeah, I think we're in for a reboot of them all, and hopefully we can get to a place where people are protected from the ill effects of the, what will come to pass if their data is used in a nefarious way to exclude them from insurance or employment. We have to protect people from these kinds of things, because I think the hope of actually truly preventing the possibility of any re-identification is fairly slim. But I'm
All
glad
right.
that you guys are
We are at
working on
2:30. I want to give a sincere thanks to all of our panelists. They were wonderful. I also want to give special credit to Natalie and Sasha and Ruan and Jill and everyone who helped make this possible. I know how painful it is to sit on Zoom all day, so I will not prolong your pain. Thank you, everybody, and have a wonderful weekend.